We would like to welcome you to today's webinar. On behalf of the Young Mumbai Center for International Arbitration and the organizers of the India Arbitration Talks, Dilbert De Viter and Rupa Matthews, I extend a warm welcome to you all. Thank you for joining us today. With our two exceptional speakers, Ila Kapoor and Ankit Goyal, we assure that by the end of today, you will be experts in third-party funding in India. Before we turn to our esteemed speakers, allow me to say a few words on India Arbitration Talks. This initiative was founded by Dilbert and Rupa last year to promote more accessible discussions on arbitration topics in India and beyond. Today already marks the third session of this series. The initiative is supported by the Young MCIA, and this is where I come in. I'm a member of the steering committee of the Young MCIA, and I'm delighted and honored to walk you through today's webinar as a moderator. It is a true pleasure to welcome our two speakers that you can see on the screen today. Our first speaker is Ila Kapoor. She's a partner at Shardul Amarchand Mangaldas in Delhi. She's qualified in India and New York. Her practices focus on arbitration and litigation in India and beyond. When I visited her website, what caught my eye was that she has been, among many other recognitions, recognized by Forbes among the top 100 individual lawyers in India. It's an extreme pleasure to have you with us today. Our second speaker, Ankit, is a partner at Allen Gledhill in Singapore, and he's qualified in India. Ankit's practice also focuses on arbitration and litigation proceedings in Singapore and with a focus on India. A particular noteworthy fact about Ankit is that he administered cases at the Singapore International Arbitration Center for several years. And I also discovered that we both graduated from National University of Singapore, but he did so more than a decade before I did. So it's also a pleasure to have you with us today. In the coming 40 to 45 minutes, we will try to approach the final question, whether India is an attractive market for third-party funding or not. In order to get there, we will first cover the essentials of third-party fundings in the context of Indian, domestic, and international arbitration proceedings, but also from a perspective of foreign arbitration proceedings when Indian parties are involved. Especially when the proceedings are seated in Singapore. At any point in time during the webinar, please feel free to raise your hand if you have a question, and we are happy to unmute you. Alternatively, you can also send me an email and I will relay the question to our speakers. Now, let's delve right in. Ila, the first question goes to you. So what is third-party funding? Who can be funded, and what kind of disputes are usually funded?
Hi, good afternoon, everyone, or whatever time zone you're in. And thank you, Janine, for the introduction, and to Young MCIA for having us here. To jump quickly in, third-party funding is basically when someone who is not a party to the dispute, literally someone who's a third party to the dispute, comes in and says, I will take part in some of this litigation costs, some or all of it, and in return, I will take a part, a sort of a percentage of the award or the award decision that you get in my favor. This is it's sort of an innovative solution. It is helpful because very often you will find that a claimant feels that they have a very good case on merits, that they have a very high chance of succeeding, but they don't have the funds to actually go through with a expensive arbitration. And this is where a third-party funder comes in and helps them, take it to culmination. It's also, it's an interesting new thing, I think. I mean, it's not very old that for the third-party funder, it's a form of investment. So these are sort of companies, and Ankit is going to talk more about how they work. But for the funder, it's a unique investment opportunity with regard to, you have the share market, you have stocks, you have property, and now this is just another sort of an investment opportunity for them to see risk and reward of putting their money into certain choice disputes where they feel that their investors will benefit by funding it. Who can be funded? Well, usually it is the claimant, because the claimant is the one who is bringing the case, and the funder is looking at finding the best amount that they can get in this case. So it could be the respondent if the respondent has a very large counterclaim also. I mean, it doesn't have to be the claimant. What kind of disputes are funded? Well, usually large commercial disputes, construction, shareholder disputes, anything where they find that there is a substantial return on their investment, they are likely to fund that. And typically these third-party funding arrangements, they differ, and they're based contractually on each party's negotiation, but they can cover everything. They can cover litigation costs, they can cover the institutional fees. So if your dispute is seated in SEAC or LCI, etc., they'll cover those costs. They can even cover evidence taking. So if your experts need to be flown in from different parts of the world, if your lawyers need to be flown in, all these things can be covered by third-party funding. It's purely a private contractual arrangement, and it's up to the parties as to how they negotiate it and what arrangement they come to. So that's sort of TPF in a nutshell.
Perfect. Thank you for leveling the playing field for the audience. So, Ankit, many individuals may now wonder why a party should choose third-party funding, and also what motivates a funder to fund the claim of a claimant or a respondent. Could you shed a bit light on that, please?
Thank you, Janine. Thanks to the Young MCI for giving this excellent opportunity. I've been associated with arbitration in India for several years. To see this young body of set up under the aegis of an Indian arbitral institution is very exciting. And while Ela and I will share our views about the challenges of third-party funding in India, one can certainly say that this mechanism of Young MCI is a bright star for guiding people and motivating people that things are moving in the right direction. So congratulations to you guys to put this together. Delighted to be over here, and thanks for the invite. Before I answer your question, one additional point that I'll make for the benefit of everybody attending. Given that we are on the Young MCIA platform, the focus of Ela and my discussion is very much on third-party funding in the context of arbitration. Third-party funding, is of course there in the context of insolvency proceedings or other civil commercial claims, but our discussion is very much in the context of arbitration involving Indian elements. Now, this could be Indian seated arbitrations, or this could be arbitrations which are seated elsewhere but have Indian aspects involved. So that's just a housekeeping overview concept for the benefit of everyone. Now, to your question on the sort of why fund, what's the business case for funding? I think there are two perspectives to this. One is, of course, the perspective of the party that's involved in a dispute, and then is the perspective of the funder. Let's talk about the party that's involved in a dispute. Most certainly, we see in many situations that there is a legitimate claim that a party has against a respondent or the other side, but does not have the resources to be able to pursue that claim. Many a times, in fact, Ela will tell you this, and Janine, you would have seen as well, many disputing parties or lawyers involved would have seen this, that the impecuniosity or the inability to fund a particular dispute may even arise out of the alleged breach or the breach of the contract. A party's got no money left because of the fact that, under the contract, they've lost all the money. And in that situation, it's an uneven playing field where the respondent has, as a consequence of its so-called breach of the contract, benefited such that it has now put the claimant in a position that it does not even have the funds to pursue that claim. Now, in that situation, the policy consideration is of access to justice. And I think that's really where third-party funding comes in. We will be talking briefly about the illegality traditionally of third-party funding in terms of champerty and maintenance. But the fact of the matter is that what third-party funding in the context of commercial disputes, and certainly in arbitration does, that it allows access to justice. It levels the playing field between a claimant and a respondent. It allows a claimant to pursue the claims. I should mention, to the point that Ela made earlier about who can be funded, it may as well be a respondent who has a legitimate counterclaim and is seeking funding as far as the counterclaim is concerned. So that's one perspective from the claimant or the counterclaimant perspective. The other is, of course, that many a times I've seen in practice, what happens is that if there's a legitimately funded case, it levels the playing field. It takes away any strategic advantage that a respondent has that has got deep pockets and can game the system. It levels that playing field. And what that leveling of playing field often does is that it brings commercial reality to parties who are involved in the dispute. And what that essentially means is sometimes a respondent will say, dude, I cannot fight this case in a manner that I will put this person out of business, or that he will not have the ability to respond to the incessant applications. But because this party is funded, it may as well be better to take a commercial decision. And that, in my view, third-party funding does, is that it aids settlement sometimes as well. So that's a second important consideration. Now, from a funder's perspective, and I think that's critical, a funder is not going to be funding frivolous claims. A funder is, at the end of the day, much like any other investor, and the success of its investment is directly proportional to the success of the merits of the case. Now, if there is a claim which is good enough to be funded, then certainly it's a claim that, from a funder's perspective, will be one where money will be able to be returned, and there will be a return on investment like any other investment that would be there. So from a funder's perspective, that is an important point. The other thing, I think, both from a funder's and a client's perspective, is that sometimes we see clients, even if they have the cash, they don't want to be using those funds that is available to a company to fund litigation. They would rather that they invest those funds in the core business that they have. So by virtue of a third-party funding, what it does is it allows a company to not exhaust its resources and its funds towards litigation and arbitration, but essentially invest it towards its core business, and therefore then it provides that additional benefit. So those are some just opening remarks and thoughts in terms of why would you want to fund and what are the benefits of funding.
Thank you. Maybe one follow-up question to this could be, how frequent do you come across third-party funding?
How frequently? Hand on heart, I have to say none of my cases up until now have been funded. In the recent times, given the change of legislation in Singapore, the specter of third-party funding does come up, and parties do often discuss it. But I think I will say this in the context of India-related disputes, much like, for example, the engagement of experts, delay experts or quantum experts. Oftentimes parties wonder, why do I need an expert? What is the benefit of it? And that I have seen that perception change in the last decade or so, and people are becoming much more amenable to the idea of the benefit of engaging experts. Similarly, I think third-party funding, certainly in the Indian context, while people are beginning to become aware, they are still not entirely sure of the efficacy of it or how it really works. And therefore, there are perceptions of, will I lose control? Will I not be in a position to settle at a terms that's best to me? Many a times I've seen a couple of occasions where the funders have not felt that, the counterparty would have the ability to satisfy the claim. So they've not been willing to fund it. So it's a combination of those factors, but it does come up for conversation for sure. I think statistics are not available in public domain, but in my informal conversations with funders, I can tell you that they are definitely busy with certainly in discussions, but also funding cases, international arbitration cases in Singapore.
And in fact, I have worked on a case with third-party funding on the other side, and actually I have not enjoyed the experience at all. But we can talk about that a little bit down when we talk about what the drawbacks of having third-party funding is. I have some, all the good things that Ankit said, notwithstanding, there are certainly some issues bringing in TPF in international arbitration or in any dispute settlement.
Okay, we are curious to hear your experience later on. But first, let's look at the legal landscape. So, not always third-party funding is just accessible. There are or there may be legal parameters and the legal framework that actually governs third-party funding. And first, we would like to look at India. So, Ila, what is the current legal position and the legality of third-party funding in India?
So actually, there's always been this sort of haze about what the legal position is in India with regard to third-party funding, with the sort of impression that it was not fully legal. For years, there was this idea that, it's not clear, is it legal, is it not, will the court enforce it or say it's against public policy? Actually, there has never in India been an express bar on third-party funding. And the concept of third-party funding in litigation, at least, was something that was very well known in India. You had something going back, decades, saying people used to buy and sell what we call cases, muqaddamas, on the unofficial market. It wasn't that there would be this sort of formalized agreement, but people would sell their stake in the litigation, whatever that stake is, or if it was an asset that they were fighting, to a funder, and basically say, here is my litigation, you give me this money, and whatever outcome it is, it's yours. And this was not considered illegal. Now, what are the reasons that some countries, like I think it's Ireland, Portugal, maybe Greece, that they don't allow third-party funding? Because in these countries, they say it's a sort of champerty, which is basically you don't allow a third party, someone who is not a party to the dispute, to come and intervene in that dispute or to fund that dispute with a fee. But in India, the position is clear that these torts don't apply to Indian law. We don't have a issue with champerty and maintenance with regard to third party funding. The rule in India actually that led to this impression and concern about the legality of third party funding was with relation to attorneys. The Bar Council of India rule says that Indian lawyers cannot undertake any cases on contingency fees. Lawyers, advocates in India cannot have a part of a stake in the award. Now, this sort of gives the impression that this would apply to third-party funders as well. And for years, there was that impression. But in 2015, there was a famous case called Balaji. And that case actually dealt with foreign law firms trying to enter India. And in the context of that, they said, yes, we do have these rules against contingency fees, but they only apply to lawyers. They do not apply to third-party funders. So that was one of the first times that there was a clear articulation by our court that third-party funding is not, in fact, illegal. And then very recently, in 2023, a famous case now here called SPS versus third-party sales, or third-party sales versus SPS, where the court explicitly, acknowledges the benefit of third-party funding. This is an interesting case because in this case, the third-party funder funds the claimant who loses the award, and the respondent then files a case against the third-party funder, saying you should be liable for the costs because the case went through because you supported the entire proceeding. And the Delhi High Court says, well, no, the third-party funder is not liable for the cost because he's not a party to the arbitration agreement. He didn't sign up for it, and it actually protects the third-party funder's rights, and it's sort of the agreement with the party without imposing an extra liability on him. So I think the position in law in India is very clear. We allow third-party funding for anyone who's willing to take these risks. You're welcome. We even have some arbitration draft committees which have been set up, which are recommending rules which will sort of ease conflict issues with arbitrators, etc. So legally, there is no bar in India to third-party funders coming in, is the short answer.
Okay, thank you. And let's turn to Singapore, because that's also, as we understand, an important seat for Indian parties. How does the legal landscape look in Singapore, Ankit?
Taking off from where Ila left off, there was, in fact, a legal bar in Singapore, unlike in India, until about 2017, actually. In India, third-party funding was considered unlawful, pursuant to the common law concepts of champerty and maintenance that Ila mentioned. But much like many things in Singapore, whenever the Singapore government and the legislature sees that there's an opportunity to further Singapore's position as a dispute resolution hub, they put their heads together and they move along. They change that position. Before I move there, I should say that there was a 2006 decision of the Singapore Court of Appeal, which is the highest court, which actually extended the concepts of champati and maintenance even to arbitration proceedings in 2006, which means that up to 2017, they were completely barred. In 2017, there was an amendment that was brought about. An amendment was brought about to certain legislations, and I'll give a very brief overview of what that was and what the intention was. First things first, they took away the aspects of maintenance and champati as restrictions to third-party funding, but that was done only in relation to international arbitrations in 2017, litigations in relation to international arbitration, and mediations in relation to international arbitration in 2017. This was extended in 2021 to include domestic arbitrations, litigations in relation to domestic arbitrations, and mediations in relation to domestic arbitration. So as we currently stand, anything in relation to international arbitration or domestic arbitration, the concept of third-party funding is legal. What they also did is that they provided certain requirements that a funder has to meet to be able to be a third-party funder. And there are some specific requirements in terms of, the setup, the structure, the amount of funding that you should be able to have. It says $5 million, so on and so forth. So all of that was also added. The additional change that was made, which was obviously very interesting, was the changes that were made to the Legal Profession Act in Singapore. And what it did was that it allowed lawyers to basically make introductions to third-party funders, but only where they do not have any direct beneficial interest in the third-party funder. What it also did, it added an obligation on under the Legal Profession Act to say that a lawyer has to disclose the existence of a funding agreement to a court or a tribunal where there is one. Okay, so those were the two sort of broad changes. One was under the Civil Law Act, which I talked about the qualification of funders, and I spoke about what kind of disputes can be funded. Then there was the second aspect, which was the amendments to the legal regulations and the legal profession, allowing lawyers to then work with funders or at least refer clients to funders. In addition to that, what has happened is three things that are critical to make things easier. They don't have the same effect as law, but they are very, very helpful. One is a Law Society note. The Law Society note captures all the legal changes that have happened, and it also captures many other aspects in relation to third-party funding. There is a Singapore Institute of Arbitrators guideline, which is a very helpful guideline, which is focused towards funders to tell them what is it that you need to do or you should do in relation to a funding agreement. It has information like what should be there in the funding contract, what sort of obligations you can take on, issues of conflict, issues of confidentiality, privilege, so on and so forth. And then finally, there is a practice note that was issued in 2017 by the Singapore International Arbitration Center, which is directed towards arbitrators. It tells the arbitrators that, what's interesting is while in Singapore, the legislation requires the lawyers who are governed by the legal professional rules to mandatorily disclose the existence of a funding, the SIC practice note directs the tribunals in their discretion to make inquiries to find out about a funding agreement. That's understandable because many of the lawyers who are appearing in SIC disputes may or may not be regulated by the Legal Profession Act in Singapore. Now, it directs the arbitrators that it can make inquiries. Once inquiries are made and information about third-party funders is available, then the arbitrators have to give out disclosures in terms of any beneficial interest or any conflict that may arise as a consequence of that. And then there are some observations, which is very interesting to arbitrators in relation to the existence of a funding agreement cannot be a sole basis to allow an application for security for cost. maybe we can discuss that at a later stage. But I thought that was a very, very interesting direction that was made under the practice note to the arbitrators to say just because you've got a claimant which is funded by a third party funder, that in and of itself cannot be a basis to allow a security for cost application. But that's a practice note. So that's really the broad legal regulatory landscape in Singapore when it comes to regulating third party funding. Ginny.
Thank you. So now we have a better understanding of the legal landscape both in India and in Singapore. But as Ila already mentioned, there might also be drawbacks when third-party funding comes in. For example, when it comes to confidentiality, when a party shares confidential information with the funder before the funding or during the funding. So I wonder, how do you perceive that in India, the drawbacks more generally, but also the confidentiality problems?
So before I talk about the confidentiality problem, let me talk about my own experience with third-party funding, which is where I feel acutely the drawback. You know, this was an international arbitration, and we actually represented the claimant, who was a foreign investor, and the respondent, who was an Indian promoter, got the third-party funding. This was an arbitration seated in Singapore. Now, it was very clear that at some point, you know, when the pleadings have been filed and the parties have a very good sense of where the case lies and, you know, who has the chance of winning, the evidence is out there, the parties entered into settlement discussions based on directions of the tribunal. And I firmly believe, with the way that those settlement discussions went down, that had the third-party funders not been there, we would have settled that case. Simply because the promoter and the lawyers of the promoter realized that their chances of winning weren't that great, right? They had a large counterclaim. It was basically very unsubstantiated, and they did not have a very good chance of winning. But the third party funder, who was, you know, and right now, I think at this point, they're all foreign international companies, right? May not have had a very good sense of the merits of the case. Usually the way these third-party funders work is they get opinions from seniors in unrelated lawyers in the market, and they give them a glimpse of the merits of the case and say, hey, what are the chances of this candidate, this party, winning this case? That is how a third-party funder decides whether they should fund a particular arbitration or not. Now, obviously, there's a huge risk here, because how much of this information are they able to give to this, you know, independent opinions that they are getting? If these are arbitrations, some of them are going on for years, there is evidence which has been recorded for years, you know, you're not going to get a very strong opinion based on an examination of all the merits, etc., to say this is a good case or bad case. Therefore, it's a risk. Like any investment, it's a risk. In any case, they refuse to settle the matter. Worked out well for us as lawyers for the claimant, because it went through rounds of hearings and we won. And it certainly impacted the tribunal's decision on costs, because had they settled, I mean, they didn't expressly mention the third party funders, but they did absolutely take into account that had the respondent in that case settled and used the offer that we had given, this case the cost wouldn't have been incurred after a particular point. But the fact that they refused to settle went against them. So this is where you have a third-party funder coming in, and there is very often a conflict of interest. And that's clear, because the third-party funder's fiduciary duty is to their investors, not to you, who is a claimant or a respondent in the arbitration. There's a conflict with the lawyers, because the lawyer's fiduciary duty is to their client, which is the party. So you've got now these three elements in any case, which are sort of struggling with varied interest, right? Even a party who brings in a third-party funder, a client who couldn't afford their case, would want to settle it at some point when they realize that, you know, well, listen, I'm getting away with this much. They don't have the control to do that. That is the troubling point, that they cede control, and they cede therefore their lawyers' control over a dispute in which they have the maximum knowledge to a third-party funder. They are not lawyers. They had not got the best grasp on chances of success or failure. These are like economists and you know, people who deal with numbers, not lawyers, is my point. And so the that is, in my opinion, a big conflict of interest with third-party funders. Um, Apart from that, there, of course, there are some other conflicts. So you have in third-party funders now who have huge portfolio of cases, so they can have 10, 20 cases going on at a time. Maybe one case is taking really long. They're seeing that the outcome of that case is in terms of whatever award it can give, it's not going to happen down the road for maybe 5 years, and let's focus all our resources on these other 8 cases. And maybe in that case, they push for settlement. So, I mean, all I'm saying is there are competing interests, and those interests are not based on the law or the merits or the interests of the parties necessarily. And that's a big, in my opinion, issue with third-party funding. And you mentioned, Janine, confidentiality. That is a concern, because obviously when you are writing to someone who's not your lawyer, or if the lawyer's writing to someone without the express consent of the client, you're waiving privilege. And there's nothing different in Indian evidence law as opposed to any other law. You're waiving privilege, and the way you have to get around that with third-party funders is you have to draw up very tightly worded contracts and agreements, non-disclosure NDAs, which will protect your information and your confidentiality with that. I think, Ankit, you also wanted to talk about the confidentiality issue.
Yeah, no, yes, Ila. While I do that, um, uh, very intrigued by your experience that you shared of this third-party funder, and I think it's a fair point, and I can see that happening, and possibly to the point that I made about the reason why perhaps any of my cases have not been funded up until now is because clients want to retain control and not want to lose control. I am told informally that as clients become more sophisticated in terms of their understanding of the process of third-party funding, they are now becoming more involved on funding agreements and the terms of the funding agreements, so that they are able to retain some element of control, and they are not letting go of complete control. So that's something that's important consideration for
Ankit,
anybody.
you
Yeah.
can absolutely, but you can see the tug, right? Because even for the third-party funder, I mean, they are putting all this investor money into this case. So how much control are they going to really leave with the party? I mean, it's difficult to see how this would balance out in a way that worked in a balanced way for both of them.
No, I think it's a question of sophistication at both levels, Ila. I would very much imagine that if somebody is putting in their money, I mean, I tell you this in terms of my discussions with some of the funders, and I hope none of them were the ones who were funding the Indian respondent. If they are liable to their investors and they've got stringent regulations or internal controls that are required, they bloody well be able to back up their decision to fund someone. So that sophistication has to come in, particularly when, as you rightly said, you're dealing with a market as India. India's a heavily regulated market. You've got laws, you've got aspects, you've got state, central, federal, state structure. You've got a lot of things at play over there. So you cannot have economists or quantum people telling you the efficacy and the merits of a claim. You've got to have your ducks in order where you're funding. And I think for good reason, because you're putting your money in it. What is the basis of your getting the money back? So I think that sophistication has to come in. And I suspect when it does, that will help reduce these unfortunate experiences that you've had. Now, on the point of confidentiality, I honestly don't have a lot to add to what Ela said. It is a genuine concern in relation to third-party funding. International arbitration specifically is extremely complex. And the last thing you want is the other party, the respondent, taking the basis to say, dude, you know what, you waived privilege because of the fact that you've given these documents to your funder. Now, Ela talked about, rightfully so, tight wording in relation to non-disclosure and confidentiality in the funding agreement between the client and the third-party funder. One additional point that I will talk about, and that's something I've seen work out in other contexts quite often, is the concept of common interest privilege. So we see that happening quite frequently as well, where the funding agreement can also expressly say that there is a common interest between the funder and the lawyer and the party, such that any documents disclosed to the funder are covered by what's called the common interest privilege. It's a legal concept, but I think any client or any party that is seeking funding should most certainly look at these aspects and satisfy itself. What is important to know is that the law that will be applicable to a great extent on the issue of privilege will be the law of the seat of the arbitration, may as well be the law of the substance of the dispute. But therefore, and as is the beauty, Ela will tell you this as well, of cross-border dispute resolution, that you've got conflict of law issues at play as well. So you've got to be able to see information, what information is being shared, what protection is there, what law governs that, and therefore satisfy yourself when you're doing the funding agreement. Seems like a bit of a hassle, but I think it's probably worthwhile given the kind of issues that can potentially arise later on if there is a funded arbitration and the counterparty moves for disclosure of documents on the basis that you've waived privilege.
Okay, thank you. And with that, we turn to our last substantial question before we come to the very final question. And this question deals with the allocation of costs. We already touched upon that several times, but it would be interesting to hear whether you think that third-party funding directly has an impact on the allocation of costs. And Ela, I think you also mentioned a case where a party then sued a third-party funder directly. So it would be interesting to hear more on that, whether this could have an impact.
Sure. So actually, again, there are no rules which talk about costs, the regular schedule of cost changing because there's third-party funding. Under Indian Arbitration Act, the arbitrator can award costs, and usually, costs are given to the winner and against the losing party. Are they influenced if there is a third-party funder? Well, if they are, it's not something that is memorialized in the award. I mean, it's completely purely in the arbitrator's head. Do they, the question is, do they feel that because a party has given the funding to a third-party funder, they will not have the resources to pay off an award and then award security? Like, that is a question that comes up. Does the fact that someone has engaged a third-party funder mean that they don't have the money, and therefore the other party should immediately ask them to post a bond or issue some sort of a security? And again, the answer is no. There's nothing like that we've come across at all. As Ankit said, sophisticated parties take on third-party funding. It doesn't mean that they don't have the funds to do it themselves. It just means that they see it as a better use of their liquid cash, as opposed to using their own money. The case that I mentioned, which was SPS Tomorrow Sales, is the one, it was last year, and it was an interesting case because, as I said, the award was passed against the claimant who had been funded by the third-party funder, and I presume that the actual claimant did not have the funds to pay the award amount and the cost amount back. And so the winning party filed a case in the Delhi High Court against the third-party funder, and in the first instance actually got an award in their favor against the third-party funder, asking for a freezing of their assets, I believe, saying that, well, if you hadn't been there, this wouldn't have happened, so you are liable because you paid for it. And then the matter went on appeal. And then that is when we have the decision from the appellate court, the division bench of the High Court, which says, well, they are not liable for the costs just because they funded the arbitration, because they're not a party to the arbitration. So I think the law is very clear. You can't impose the cost on the third-party funder. And I think that's probably a good thing, because that would be the death knell of third-party funding if that was to happen.
Unless, Janine, if I may, I suspect you were directed to me. Yeah, okay. Unless, of course, Ela, and we've seen that conversation happen as well, where the funding agreement says that the funder takes on the responsibility for any adverse cost order or award. And in fact, in the Tomorrow Sales case, SBS case that you're talking about, the Delhi High Court Division Bench, which was looking at the single judge's Section 9 order of freezing the assets, whatever, of Tomorrow Sales, actually looked at the terms of the funding agreement, and it said that there was nothing about the funder taking on the responsibility of an adverse cost order. Having said that, yes, you can of course have situations where a funder takes on the responsibility of an adverse cost order. So that would change the situation. Just one additional point that I wanted to make, which I did allude to when I was talking about SIC practice note earlier, is that the practice note, as I said, directed towards the arbitrators, has a particular paragraph 9 of the practice note, which specifically talks about what happens if there is an arbitration that is funded and a respondent says, you know what, the claimant has gone to a third-party funder, which clearly means that he does not have the funds to fight this case, and not to cross the T's and dot the I's, but to the uninitiated, the concept of security for cost essentially entails that where there is a claimant which is impecunious and may lose its claim, it may not have the ability to satisfy a cost award which will be given to the respondent. A respondent can make an application and a tribunal can order for the claimant to give security of the respondent's costs. Now, the question is, just because you are funded does it mean that it aids towards an application for security for cost? Paragraph 9 of the practice note says that should not be the only consideration. You should look at other factors. And as Ela mentioned, that there might be claimants who have the ability to fund, but they're choosing not to use their own resources, but are using the money available from a third-party funder. So that's just the additional point in terms of the practice note. I do urge the attendees to go and have a look at it, just in terms of familiarizing themselves as to how the SIC rules have that provision. Unfortunately, I mean, I've not had a discussion about this with the MCI, but I will make a note to tell Neeti and Madhukeshwar to look into beefing up their rules to at least have some sort of a reference to third-party funding. Perhaps that's best done after Ela and I have shared our response to the main topic, which is that whether it is an attractive market for third-party funding. But I think the MCI rules should be in sync with how things are moving along globally, and I think it's worthwhile for them to look at third-party funding from that perspective. Back to you, Janine.
Thank you. So now that we've covered the basics of third-party funding, we assess the pros and the cons, and also the impact on the allocation of costs, the adverse cost orders, and the security for costs. I think now we are in a good position to answer the final burning question and the topic of today's webinar, whether India is an attractive market for third-party funding. So what is your view, Ela, on this question?
So my view is not at this point in time, not till some of our delays in our courts and our litigation processes get more streamlined. And for the simple reason is that, you can have an international arbitration, which we all do, seated in Singapore, run by SIAC. You can have a tribunal of experts from around the world, and everything will run on that case like clockwork, like it does in any other case, even if it's substantive Indian law, etc. That's not the issue. Till that process is going, the third-party funder is dealing with unfamiliar ground. This is what he does all over the world. There's going to be no difference. What happens when that award, which is in his client's favor, needs to be enforced in India? The problem is that enforcement of awards in India are very slow, and not only are they very slow, there can be some surprises along the way. We've had a very famous case recently, which has made all the newspaper headlines, in which the Supreme Court, in a curative petition, which is literally the second appeal in the Supreme Court, so it was something like the fifth appeal after the person had won the award, overturned the award. And a curative petition, just to give context, is really used in the very, very rarest of the rare cases, not in commercial cases. So this was an award that was passed in favor of the party in 2017. It went through 5 rounds of court appeals. And finally, in 2024, the Supreme Court overturned the award. Now, if you think about that situation, although I do want to caveat this by saying, look, it's not very common. At least it's not very common so far, and I hope it doesn't become very common after this decision. But if you think about this case, where does this leave the third-party funder who funded, supposing he had funded this award, which he got, 8 years down the line, it's overturned. There's too much uncertainty in the Indian market still in terms of what the outcome will be, and the process itself is too long. And Ankit and I were discussing this yesterday, and he actually pointed out rightly to me, the lacuna is that courts in India are not going to pay actual costs. So the entire duration that the challenges are going forward, you have the recognition of the award, you have the enforcement of the award, then you have execution of the award. This entire time, you're not likely to, you're still paying your lawyers, and you're not likely to be able to recover those costs. So those are sunk costs for the client and for the third party funder. So these are the main reasons why I think are a challenge for third party funders funding disputes in India. When things become more streamlined and quicker, I think will be a great market for them to come in, because I think we have the largest number of disputes probably. I know that we are one of the largest users of, for example, SEAC. Forget MCIA. So, even internationally, we are one of the largest users. There's no shortage of disputes in India. Problem is, as I said, there is a lack of certainty, which there should be, especially in relation to arbitration awards, which we only go into ADR because of their certainty. So that's what I think.
Ankit, do you agree? Do you disagree? What's your view?
There's nothing to disagree. It's Ela. I would pick up from where Ela's left off. Uncertainty is anathema to third-party funding. Actually, uncertainty is anathema to anybody when it comes to commercial aspects or commercial disputes. And I think Ela's covered most of the points in terms of uncertainty. I mean, let's look at it, right? I mean, while a client, a party that has got a claim is important, at the end of the day, it's a third-party funder. He's in the business of funding disputes, not for the sake of joy. He's in the business of doing so, meaning thereby that he needs to have certainty. There has to be there are now finance professionals who are sitting looking at multiple financial jargons of EBITDA, rate of returns, cost of capital, so on and so forth. So they need to have some level of certainty. And unfortunately, in India, there is some element, if not a great element, of uncertainty when it comes to, even if you win your arbitration. And I should make the note and say it that there have been big changes that have been brought about in recent times, whether it is by virtue of amendments to the Arbitration Conciliation Act in 2015, 2019, whether it is by virtue of the two big decisions of the Supreme Court of India in relation to stamping of documents or in relation to group of companies doctrine. Supreme Court has come in and set the thing, correct. But unfortunately, then you have decisions like the DMRC where, roller coaster of the Indian arbitration, or 2 steps forward, 1 step back of Indian arbitration. So that uncertainty feeds into the doubt of a third party funder to say, look, if I were to fund this, when am I going to see the money out eventually? So 2 aspects, economic aspect, economic issues in relation to third party funder perspective, inability or the uncertainty to see the money back, right? Ela's already talked about some of the aspects. I wanted to mention one additional one is that many a times the claimants in arbitrations in relation to Indian disputes are against Indian public sector undertakings. And again, Ela and I discussed this yesterday. Public sector undertakings will most often not apply themselves on the merits of the success in a setting aside proceedings or opposing enforcement. They will do so by virtue of just exhausting their statutory remedies. And that can then add to the whole process. At the end of the day, the Delhi Metro Rail Corporation was a PSU, so that's case in point for us as well. There are, of course, some discussions in India in telling public sector undertakings to try and settle and reduce the workload, but I think that's still work in progress, and there is some element of delay as far as that is concerned. The other aspect, which I should mention, is in relation to third-party funders, Ela and Janine sitting in Singapore, and their inability to fund India-related disputes. even though the seat may be Singapore. And those issues are predominantly twofold. One is exchange controls, and the second is tax considerations. Now, in terms of exchange controls, the funding agreement is between a client and a third party funder. Say, for example, you've got an Indian client and a third party funder based in Singapore. If you are making an investment into the dispute and if you are funding, the question is it a capital account transaction? Is it a current account transaction? By the way, the FEMA and the Reserve Bank of India does not say whether this is a capital account or a current account transaction. And that has deep implications, by the way. I mean, I'm not a FEMA expert, but I'm told that if you don't know what it is, it may as well be that these investments or this funding is disallowed pursuant to India's exchange control laws. So there is a big stumbling block from any third party funder to say, I mean, I can't be funding if there is uncertainty or lack of clarity in terms of funding. That's a funder seat, sitting over here in Singapore. The other aspect is tax. I think there is fair amount of uncertainty in relation to tax. There is withholding tax issues that are there. Is the amount taxable in the hands of the company that receives it? Is it taxable in the hands of the funder that receives the money after the award is paid out? Although I don't know whether that will happen or not, but tax considerations are important considerations. That's a bit of a stumbling block. And I'd say these economic issues and the regulatory issues that I've highlighted are stumbling blocks, are challenges. Does that mean that India is not an attractive market for third-party funding? Possibly not. I mean, to Ila's point, there is no denying the fact that India is a litigious society. It is a well-established in terms of its legal infrastructure. There is rule of law. And generally speaking, there is confidence in the courts. So, and I should say, although everybody knows this, India's embarking on what can only be said an amazing journey of economic growth. And it's only going to become better. So therefore, India is definitely an attractive market for third-party funding, but challenges are aplenty, and I think those need to be addressed. And I have to say this, that if recent times are anything to go by, which I alluded to, India's doing exceedingly well in rectifying and addressing those challenges such that they can do away with any stumbling blocks and make it easy, not only for people within India, but people from outside India to do business in India or to resolve disputes. So on that positive note, that's my hope for third-party funding in India.
Thank you so much. So with that statement, we probably come to an end of this webinar today, and we can open the floor if there are some questions from the audience. I see that some people are already logging off. So if anyone has
Janine, that's the benefit of having Ila. They've been so eloquent and clear that the people have had absolutely no questions. In fact, questions have been answered before they have been thought of. And it's down to your incisive questions, Janine.
Yeah, I hope. Yeah. So, there is one. No. There was one. No, there are several. I will unmute you, Rupa. And
I think there are two others, so maybe you can go ahead and take the others.
Okay, so it's Meghna and Ganesh as well. You're unmuted. You just have to unmute yourself, or I can try.
Hi, am I audible?
Yes.
Okay, my question is, do you think, and it's particularly to Ila, do you think it's best that the legislature moves first and addresses any concerns that may arise later, and therefore expecting what may happen later in terms of growth in third-party funding, make laws already?
So, sorry. So your question is, do you think should the legislature move first? And I think that when I mentioned that there were two committees, which were, they framed suggestions with regard to how to regularize third-party funding, including by amendments to the Arbitration Act. So, for example, when we're talking about conflict of interest that the arbitrator has with a law firm, we should include in that, one of the suggestions was we should include in that third-party funders in the definition of affiliate. So there are already legislative suggestions to regularize the issues that might arise from third-party funders in India. And as I said, I don't see that as the big stumbling block. The problem is, of course, the enforcement of courts, and that is not something that the legislature can, legislate on.
Right, thank you.
Ganesh, if there is a question, you can unmute yourself, but you should be allowed to unmute yourself now. And the same goes for Adarsh, if you have a question as well.
Hi, am I audible?
Yeah, you are.
Great. Thank you, Ankit. Thank you, Ela. This was extremely informative and gives a very good picture of how third-party is functioning right now. Now, I understand, Ela, that you mentioned how India is not ready for it at an enforcement level when it comes to third-party funding, and we never know. Maybe regulation changes the way it works or it doesn't work when it comes to third-party funding. But what I want to know is how institutions, now assuming that we do have third-party funding and it is happening, can institutions take a step forward and make regulations or practice notes, as Ankit suggested, that SIAC has it, right? And like, for example, MCIA themselves can take a prerogative that before regulations come in, and before we go into the whole enforcement debate about it, can institutions have, for example, disclosure obligations? Because from what I remember, SIAC has, like, as a part of the regulations, Stockholm and SIAC, they have these regulations which talk about disclosure obligations, which with an arbitrator or someone to avoid the conflict of interest with third-party funding. But can there be steps which institutions can take up on themselves as a mandate, which can streamline this better?
Absolutely. Ankit, you want to take that one?
Yeah, no, I'll just, it's very interesting you asked that question, Adarsh. The Queen Mary survey on international arbitration in 2018 had a question, and the question was in relation to the role of arbitral institution. 85% of respondents said that arbitral institutions play a pivotal role in basically changing the landscape of international arbitration. So to your point, the answer is yes, I think arbitral institutions do play a pivotal role. The fact that we are sitting on a young MCI platform and discussing and having a dialogue about the challenges associated with third-party funding, I think is a step in the right direction. Certainly, as I said, MCI should relook at its rules and in fact have provisions which provide further clarity and address situations, for example, the one that Ela mentioned, so that there is larger level of trust and builds upon the sophistication both of the funders and the users of arbitration. And that's going to aid for sure.
Thank you, Ankit. This was extremely helpful. That makes sense. If I can ask one small more question.
I think there was somebody else as well, Janine. Adarsh, to be fair, we should.
There is Ganesh. I'm not sure if you can unmute yourself now. Ganesh? That doesn't seem to work. Then there was also Shivan. I'm not sure if you want to chip in as well. Shivan, you should be unmuted. Or you have to unmute yourself if you can.
Hi, everyone. Yeah. Am I audible?
Yes,
yes, Shivan.
Hi, good to see you all. Ankit, good to see you after COVID. And Ela, good evening to you. So my question was partly asked by others.
Shivan, your audio is not clear. At least I'm having trouble hearing you.
Is it clear now?
It's better now.
It's better? Okay. So Adit has already asked the question which I was looking for. To add on to it, how do you see the role of capital institutions in relation to the investment dispute and the investment related rules? The role of, with respect to the third party funding, the rules with investment rules. So we all talked about the commercial aspect and the third party funding in commercial arbitration, domestic, international. So how do you foresee for the investment related dispute and how
So you,
important it is?
if I understand this
What
correctly,
role?
Shivang, are you talking about treaty arbitrations,
Yeah,
ISDS related
that's
disputes?
the extent there.
To be honest, to be fair, in my bad that when we started the discussion, I should have highlighted that the focus of our discussion is predominantly in relation to commercial arbitration. Investment treaty arbitration, Shivang, as you're aware, is another beast altogether. And I think the considerations in relation to third-party funding in investment disputes is another topic completely. Just to give you a sense, there is a fair amount of heartburn by governments that feel that by virtue of funding of investment disputes, there is an unequal platform that is being created where the claimant is actually having a lot of resources to pursue investment disputes. So there are absolutely different consideration when it comes to investment treaty arbitrations. I do know that, I can point out that the SIC investment arbitration rules does have an express provision in relation to third-party funding, and definitely third-party funding is very active in the context of investment treaty arbitrations, but unfortunately, we don't have the time to discuss that, and the considerations in that very different, which is why we thought we'll focus on commercial arbitration.
But if you're
All right, thank
interested,
you.
there's a very famous, not very famous as these things are, except to a bunch of nerds like us. The case is Panthera Resources, and they've just got a big TPF support for their claim against the government of India. So you can look that up. Because you're right, in investment treaty arbitrations, I think those are particularly suitable for third-party funding because obviously the government is a big, whatever government you're suing is a very strong commercial party, and the commercial party that's bringing the claim against the government could use the support.
Thank you.
So, Ganesh, do you want to give it another try? I think you have to unmute yourself on the top bar. Okay, if that doesn't work, shall we give the last question to Adarsh? You still had another question, and then Ganesh, you can still shoot us an email, and I'm sure you will get an answer. So,
Hi, sorry. Yeah. Am I audible, right?
Yeah, you are. Just go ahead.
It's a little different question, maybe, but in the context of India as an economy right now, and third-party funders, because there is no regulation which governs on who can do it and what is the composition of them. If financial institutions come into this place, like banks, say, for example, any private banks end up doing something like this for arbitration funding, they have a larger capacity to take risks if in case they do enter. Will that change things? Like, will that change the dynamic of how disputes can work out? And maybe the issue where a bank would not want them to not settle or something like that, like an experience which Ela had shared, something like that cannot happen. But do you see that as a positive sign if large financial institutions also start an entire wing of investing into arbitrations and disputes, becoming a third-party funder?
I could take that. I don't know that there will be very much difference between what we have now. But the point is that they all need to be regulated. Whether the funder is a sort of a offshoot of a bank or a division of a financial institution or set themselves up as a third-party funder. The important thing is that they all need to be regulated in a particular way when they go into these investments. So what constitutes the funder, I don't think is significant. What is significant is that they need to follow the rules. They need to make disclosures about what their connections are with the present dispute, with the lawyers that are dealing with the dispute, with the arbitrators, and those are the kind of things that need to be done across the board. I don't think it will be very relevant as to whether it's banks or other financial institutions.
Got it. Thank you so much. Thank you so much, Ankit. Thank you.
Okay, so with that, we definitely come to an end of today's webinar. We learned that India is or could be an attractive market for third-party funders, but that there are some stumbling blocks. And yeah, now you have 2 persons that you can go to if you ever come across any issues, or if you want to have any advice on how to fund your claim. We are sure that you are now all experts yourself, and we wish you a very nice evening or afternoon wherever you are. And thank you also to Ila and Ankit for taking the time. It was really a pleasure, and also on behalf of the Young MCIA, we really appreciate your presence here.
Thank you, Janine, and thank you to the audience, and to Ankit, thank you all of you.
Yeah, thanks to everyone.
Thank you.
Okay.
Bye.
Bye.